is the instruction about the defendant's recorded statement. Okay? It outlines for you what the requirements are for the state to give you the statement and for you to consider it. Okay? The statement speaks for itself. Okay? And you can ask for it and you can watch it. And you can watch Detective Rulin read every single one of the Miranda warnings to this defendant. And you can watch him acknowledge affirmatively. And you can watch him waive those rights. Okay? He knowingly and voluntarily waived his rights and agreed to participate in the interview.
Which one? 1 second, because I want to pay attention. All right, sir.
It's pretty clear that the defendant knew what he was doing. It's crystal clear that he wanted to talk. Okay? He understood his warnings. He's an intelligent guy. He voluntarily and knowingly waived them. And then he participated in an interview for over an hour. He asked questions. He challenged Sergeant Ruland on certain things. And then eventually he asserted his rights. Okay? So, this is an issue for you to consider. It's not a big issue. Okay? It's pretty clear that Andre Jackson knew what he was doing when he sat down with Sergeant Ruland. All right? The elements that are outlined in this case. Guys, most of them are not at dispute here. Okay? Nobody disagrees about how and when and where Josue Flores lost his life. Okay? That's crystal clear. We all know that. The only question is, who did it? Andre Jackson did it. And you know that beyond a reasonable doubt. Because over the course of a week and a half, you saw quite a bit of evidence to support that. Ask for this evidence. Okay? After you get back there, send a note to the court requesting all of the evidence. You can look at all of the videos. You can look at the defendant's statement. You can look at all of the photographs and the physical evidence and the map and the DNA chart. That's all there to help you. Okay? So ask for it. Look at those things. Talk about those things. There are some things that are not evidence that you may want, but you're not going to get because they're not submitted as evidence. Okay? This offense report that we've been talking about off and on through these various officers, okay, that's not evidence. You don't get that. You can't consider that. Wouldn't be easy if the officers just wrote an OR and then we just dropped a book in front of you and said, there you go, figure it out. Okay? That's not the way it works. You listen to witnesses. You gauge their credibility. Like the defense said when he was cross-examining Lieutenant McCallany. You got to look at the good, the bad, and the ugly when you are assessing credibility and reliability. Okay? And that's up to you. And guys, we brought you a lot of good stuff, and we brought you a lot of bad stuff. We brought you a lot of ugly stuff. Okay? Consider it all. And I suspect that the defense, speaking about witness testimony, I suspect that the defense is going to tell you that you can't rely on these witnesses. The citizen witnesses were all over the place. Okay? But I would actually argue that their inconsistencies actually prove that they're telling the truth. They got some things wrong, but they got the big things right. Who they saw, where he was running, what he was carrying, all of them talked about that green jacket. All of them described Andre Jackson the same. All of them pointed out the direction that he ran. And they were proven right by that video at Henry Street. So the fact that they got little details wrong, well, it shows you that they didn't get their story straight before they took that stand. They came in here and they told you the truth. I also suspect that the defense is going to tell you that the DNA, that you should ignore the DNA, that the DNA is bad because it was so little. And I can see why that would be a tempting argument. But you heard from 3 experts, 2 from the state and 1 from the defense. And while they disagreed about certain things and they had different theories, the one thing they all agreed on is that the DNA is reliable. And the DNA tells you that Andre Jackson contacted the victim, Josue Flores. And guys, there's only one explanation for that. Okay? All of these theories about contact transfer, secondary transfer, and all the rest of that stuff makes sense in a lab, but not in the real world. And we live in the real world. And it's your job to decide what's reasonable, not what's possible, not what's theoretically possible, but what is reasonable. And while it may be possible that somebody could have touched the victim and then run many, many blocks, crossed a train line, and then run to the Salvation Army, and then opened the door to get into the Salvation Army, and then gone about his business, and then somehow, somewhere, gone into Andre Jackson's room and touched that jacket, and then left the victim's DNA on the jacket in a greater proportion than his own, while that could be theoretically possible, that's not reasonable. And DNA only matters in context, and the context for this DNA and what you have seen is that Andre Jackson was 2 blocks from the scene of a horrendous murder, wearing clothing described by multiple witnesses, fleeing the scene of the murder, putting on the jacket, just like they said he was going to be, putting on the jacket on a hot May afternoon, then running more blocks, and then taking an indirect route back to his home. He didn't run up Main. He cut down Winnie. He went the back way. And then the victim's DNA is on that jacket. The reasonable conclusion here is that the victim's DNA is on Andre Jackson's jacket because he murdered Josue Flores. Andre Jackson is a killer. He killed a child. And the evidence is right here, guys.
Thank you. Scott.
Can I have a moment just a second? There is this saying, and it was when I was a prosecutor that some defense attorney told me when I was giving him a hard time. No one likes a criminal defense attorney until you need one. When y'all went home last night, you thought to yourself, because you have at that point heard all of the evidence, whether or not Andre Jackson was guilty. Every one of you did. And that's okay. but close your eyes. All of them. Indulge me, just close your eyes. And ask yourself, clear everything about this case from your head. And ask yourself again about your vote last night. Okay. Now, your vote in your mind last night, none of what we say now realistically should change that. Because what we say is not evidence. And so, if one of your questions last night that you answered was, he is not guilty, then it doesn't matter what any of us say in closing arguments. If you said to yourself in your head and you had trouble sleeping, I don't know, I'm not sure. That's the definition of reasonable doubt. Like it or not. If you said, I think maybe, possibly he's guilty. This is reasonable doubt. You might have said to yourself, he's guilty. And you paused, and you hesitated, and you second-guessed yourself. That is the definition of reasonable doubt. And if you said he is guilty beyond all reasonable doubt, you owe it to this Marine, combat veteran, to question yourself again. You go back and you start with that presumption of innocence. You know why you do that? Because that's the law. That's what it is. We don't have the burden of proof. Not one iota of proof. We don't got to prove nothing. We said in Bordier, we don't have to ask a single question. None of it. The presumption of innocence, not evidence alone, is sufficient to acquit the defendant. And listen, unless you're satisfied beyond, this is what the jury charge says, unless you're satisfied beyond all reasonable doubt of his guilt after a careful and impartial consideration of all of the evidence, then you don't get to a guilty. In fact, you must assume that the absence of evidence, this is so important, you've got to assume that the absence of evidence readily attainable by the district attorney's office and law enforcement and not given to you, if that is not given to you and it's available, you must presume that that evidence was beneficial to Andre Jackson. Because I wasn't there to decide what evidence they collect and do not. Because let me tell you, if one of us had been there, we'd have done a whole lot of swabbing and a whole lot of questioning. But we weren't there. And so we are dependent on them. And any piece of evidence that didn't bring you, that is evidence that Andre is not guilty. He is constitutionally presumed innocent. There is no other presumption like that in the world. That is how powerful. Nowhere else in the law is that. Missing evidence? Moldy evidence? Don't worry about it. It's fine. No. That is evidence that would have found Andre Jackson not guilty. That is not our fault. And it's not yours either. But it is our problem. They told you that we are one community. We sure are. And what you say matters. This case is every defense attorney's worst nightmare. It is a textbook example of how innocent people get convicted. Make no mistake. And I'm going to talk about this in a few minutes, but one thing that is not evidence are emotions. It's okay to be emotional. This is an awful case. I thought about my mother a lot because she always says, no parent should ever have to bury a child. What that family has gone through is awful. It is terrible. But as much as the state wants those emotions to be evidence, they are not. Because if you convict this homeless Marine who was just trying to get back on his feet, it won't be because of the evidence. It'll be for the lack thereof. In fact, it'll be because you can feel it. Can you feel the pressure? Look at this packed courtroom. Can you feel it? You can. But all these people, they didn't hear what you heard. They're not sitting in your seats. I'm not saying that your job is easy, because it's not. But it's okay to find him not guilty. You should be just as proud of a not guilty as a guilty, because you did your job. And HPD and law enforcement didn't do theirs. Important that you stand firm in your convictions while you are deliberating. Do not let anyone convince you if you aren't comfortable. I don't care if it's 11-1. If that's what you believe, you stand by what you believe and what you know. You can also challenge that other person and say, if y'all are debating a long time, look at that person in the eyes. Tell them, the fact that we're even having this debate right now is reasonable doubt. You know what kind of case this is? You know what kind of case this is? This is a screw that guy case. That's what this is. It's a screw that guy case. What does that mean? Well, did they get identifying information from the ATM without a warrant or subpoena? Yeah, they probably did. But screw that guy. He's charged with killing an 11-year-old. Look. This is just very telling, so I'm going to take the time to show it to you. If I can find it. When you look at the chase records that the law enforcement says they got, and that's how they tracked them down, look at the date on that business records. They didn't get those records until after the defendant was arrested. How did they then know? Look at that business records affidavit. So, how did they know? Do you care? Screw that guy. What does that matter? Are the timestamps on the video correct and accurate? Close enough for government work. We think they are. They're a few minutes off here and there. That can't possibly matter. Screw that guy. It doesn't matter. HPD has resources and technology to conduct proper investigations. Did they send out someone with the technology to confirm that those devices are working properly? Nah, they just had a homicide detective go burn it on a thumb drive. Is it possibly wrong? Yeah. Don't worry about it. It's fine. Screw that guy. Not a single photo spread of Andre Jackson where any witness identified him. None. We saw how photo spreads worked out with Shay Calhoun. Well, it's better not to show them so that they don't create evidence favorable to the defendant. They had a terrible, terrible tunnel vision investigation. Emotions are natural. It's part of being human. But they are not evidence. This should terrify you that Shay Calhoun was arrested and charged with murder within 30 hours. 30 hours. And what did Lieutenant McGowan say on the stand? All they had was a photo spread and some surveillance video of him in the area. Okay, great. We charged him. Brought in someone else for questioning, arrest Andre Jackson, then dismiss his case in July of 2017, and then refiled it in June of 19. So it's okay, though, if the police get your personal identifying information, all they have to do is ask people for any of your private information. They don't need a warrant. They don't need a grand jury subpoena. It's all right. Don't worry about it. You okay with that? Where are the rest of the Metro videos? In their own clip, they actually see the Metro rail and the camera that would have shown from the front of the Metro rail coming whether or not someone else was also crossing at the same time. It would have shown you a lot. Did they get it? Nah. Wouldn't you want to know what time he crossed the rail to start? That would be nice. Because it might corroborate what Andre Jackson told law enforcement. You can't have it because they didn't bother getting it. They don't even know what's on there. They don't even know what's on all the video you have in evidence. At the pre-press conference, all the evidence pointed to someone other than Andre. And who are they looking for? And Mr. Godnick's going to talk about that. But basically, it's someone wearing a white shirt, and that was confirmed by Josh Hubbard. And I'm going to go through some of this quickly because I want Mr. Godnick to cover it. But I will say this. It was amazing and miraculous how the 13 of you saw everyone's testimony change and then kind of mold into something that was consistent on the important details. That is terrifying. You can't blame them, but you cannot believe them. They wanted to help Josue. Can't blame them, but you can't believe them. When Guerra is interviewed a year later, he's wearing a Justice for Josue shirt. And his testimony on direct was, "Don't die, Josue, don't die." And the prosecutor was quick, wasn't he, to point out, well, you didn't know him then, right? Because it colors everything he's telling you. I think at one point Josh Hubbard said on the witness stand he was uncomfortable telling the police everything. Does that sound familiar? It sounds like what Andre Jackson said. But they believe Josh Hubbard when he says that, and so you should believe Andre Jackson when he says that. Okay, McGowan timeline, 12:45 a.m. they obtain an arrest warrant. 1 p.m. they execute the pocket warrant. At 2:36 the interview starts. So from 1 p.m. to 2:36, Andre Jackson is in handcuffs, probably sitting in the interview room for at least an hour, cuffed. Prasad, the CSU, is dispatched at 3:50. You know how you have that saying that the ink's not even dry yet on a document or something before someone does something? There was no ink on the paper before they dispatched the crime scene unit. Pretty presumptive that the judge is just going to sign your warrant? Sure. And it's a rubber stamp, right? Because that guy killed an 11-year-old. So we'll just presume, there. Look at this investigation. This alone is enough to find him not guilty. This part right here. Look at this. Not a single swab was taken from his room. How do you do that? You're supposedly in the killer's house. And you don't want to take a swab? Anywhere? Nowhere? Are you serious? There's no video that they took from the Salvation Army? Where's the video? They didn't bother collecting it. Well, I think that'd be important. Maybe you would be able to tell what time Andre Jackson left and what time he came back. No pictures either of the metal detectors. Those would have gone off that he's carrying a knife. This is beyond explanation. Don't you know? They would have taken that can of luminol and poured it all over that floor, turned off the lights, because you know that there must have been some blood. If it was on Josue's shoe, unless the killer was like, oh, don't touch my shoes, they're going to come get them later. There's no blood. That is enough. You should be very concerned, because when you look at it, they don't examine the community showers or the bathroom. They don't interview people except his three roommates later. 2 weeks later. Where's the roster? They don't take photos of the roommates, consents to search their lockers. No luminol, not a drop. Lieutenant McGowan tried to say that when they executed the pocket warrant, they immediately saw this jacket, right? And then they get a little closer, and they're doing everything they can, right? But when you see, he said one thing in a previous motion, when he said, oh yeah, you could see the lettering on the jacket. You can see it. But then, in front of you under oath, he realized his mistake. You can't see the lettering on that jacket. He caught it before he testified in front of y'all. Does that matter to you? That means they manipulated that bag. And if you manipulate it, that's a search. You think they were just a little curious? Did they follow the law? Or did they break it just a little bit? Is that okay? Screw that guy. Wait until I do it to another guy. So, do we get consent to search the other lockers? What if it really was his roommate? Is it possible? Yes. They might say, as ridiculous as that sounds, they may say it is. But all you have to know is that it's possible. Do they even bother checking up? The guy's in prison for robbery. Don't worry about it. We got our guy. Compare the investigation of the room of the suspect, right, Andre Jackson, and compare it to what Officer Leon did, just at the idea that he was at the game room. Look at this. Look at what he did. These are the pictures I put into evidence right before we closed. So he's taking pictures of the outside, right? Oh, look, he's taking pictures of the security camera. Huh, that's interesting. Look at the video. Oh, look at that. They're not worried about the killer's room, but they're taking swabs from the game room. That is how you do a crime scene investigation. Look at, he takes the swabs and everything, he's documenting it. Nothing. When you look at it, Ruland arrested the wrong guy he swore under oath was the right guy. You remember, everything they did not do should be presumed to show Andre Jackson's innocence. I'm not talking CSI stuff here, like the prosecution had you take that oath. This is real life, not CSI. Did they deploy a canine at the scene? That might have helped. No evidence of that. Oh, but they did tell a witness to just destroy some evidence. Delete the photo on your phone. Might have been helpful. They told patrol units to stop asking questions. Stop messing up our tunnel vision investigation. We got the guy we want. But when you think about it, they did not want inconsistent statements. Because the truth never changes. Right? But if you have inconsistent statements, it might show that Andre Jackson didn't do it. Hey, stop. Stop investigating. Stop talking to people. You're messing up our investigation. But isn't that okay? Because after all, what did Sergeant Rulin say? He just wants the truth. That's all he wants. Was there any search for weapons anywhere around there? Was there a list of the people staying at the Salvation Army? Surveillance video from the Salvation Army? Why doesn't anyone ever try to backtrack the time frame from where Andre was coming from? That would be nice, wouldn't it? That would be a helpful piece of evidence. Don't worry about it. The jacket was now mistaken for a trash bag with a heavy object, a backpack, and just the inside of the jacket. This is the best. This is the best. Every time one of us asked and questioned why they didn't do something in the investigation in 328 pages, what was the answer? Oh, we did it. It's just not in the report. Is that okay with you? So it's not in the report? No. Every time it's something that helps him and we ask about it, they did it. Trust us. We did it. We just forgot to document it. It should terrify each and every one of you. Just trust us, bud. Because it's just like what Rulin said to Andre Jackson. I can help, just follow my lead. I want to talk to you about what we call the exclusionary rule in Texas. This is what the part of the law that you get to make a choice on in Texas, right? And so you get to decide whether someone knowingly, intelligently, and voluntarily waived their rights. This is really important in Texas that we give this chance to a jury to debate and decide, all right? If you're not satisfied the person knew what they were doing, then you must disregard the evidence and not consider it for any reason. If you are not happy with the way they baited him into that statement, into waiving his rights without even realizing what he did, you should disregard the statement. But I want to be clear. The statement's fine with us. I'm sure that they can pick apart and show you little clips of his statement, but when you watch it as a whole, all he wants is information.
You've used about 25 minutes, sir.
That's right. Okay? You have to disregard it. Why is it something we're challenging? We'll embrace his statement. But here's what and he actually says he feels sorry for the family. He does get annoyed. You don't have to like him. You might find him odd or weird, and that's okay. But he starts getting annoyed, and he's asking questions, not fishing for information, just like what Rulin did when he was on cross-examination, when he was asking me questions to make sure that he understood. I said, are you fishing? What are you guilty of? It's the Rulin rule, okay? Charge first, investigate later. It doesn't make Andre guilty either. It's easy for you to say how you would behave, but you don't know until you're in that situation. It's actually what Rulin didn't say. That's why this is in there with the statement. When I asked Rulin, right, when I asked him, what what, this is what I asked him. This is important, right? Andre Jackson, I told him he was going to jail and getting charged with the murder no matter what. Isn't that right? It killed me. It was at 2:37 in the morning that I realized what he was saying without saying it. He disagreed, but he didn't follow up. And I realized the answer to my question that I didn't ask was, if Andre Jackson had not said or identified himself, they could never have charged him. Nobody else ever ID'd him. So if you disregard the statement, which you should take a good look at, it means they've got no identity. I didn't ask that follow-up because he said it depends on what he said. You have to stop and think about that. Are you okay with the persuasion used? You should not be. It should trouble you deeply. That's why the DA's office has to play the statement and then try to just discredit other things in there. They have to have the statement, or they got no ID. Andre is challenging them in his statement because he knows they don't have video of him killing Josue because he didn't do it. You think about that. They're saying, well, yeah, we got you on the street. And he's like, okay, show me. He's challenging them because he knows he did not do that. So they leave him in handcuffs for over an hour and a half. That's not a safety issue. Patrol is right outside. They read him his rights, but they don't follow the end of the blue card that they get by the DA's office. They initiate this kind of baiting, reel him in, and then he doesn't realize what he's done. Then they get conversational, slip in an okay, and they're ready to go. Is that really an intelligent, knowingly involuntary waiver? It's per se persuasive. And you, all 12 of you, get to make that decision. Maybe it's a screw that guy moment for you. Boy, let's focus on those roommates, huh? This is important. The FBI video. Remember what the judge said. This video is not evidence. It's not. You will want to go play with it because even I think it's cool, right? But it has the prosecution's theory about what happened, but that's not evidence. It's very cool. You can click. Here's the question: can you click anywhere and measure other paths? No, you can't. Did anyone bother asking the defense to put in their hypothetical path? No. FBI's like, just give us what you want. We'll take care of it. They didn't even read the whole report and factor in other information.
You reached about 30 minutes, sir.
Yes, sir. That video didn't capture Andre turning from Gentry, and he had him on Henry Street, a location in a time that would have made it impossible for him to commit the offense. If we assume the HISD time on the video is correct, then every other video, with the exception of the second surveillance video, is consistent with the HISD time. That means he didn't have time. Guadalupe Ramirez, hers is off by 10 minutes. Francisco Najera couldn't even tell you if the timestamp on his video is correct. Metro PD says theirs could have been off by a couple minutes. You think about that. Where was the expert to download the videos? You just take everyone's hard drive, and then you give it back to them the next day, and you take it back and you download the whole thing. That is a good investigation. Okay, I didn't catch this until this weekend. when I was rewatching stuff. So we are looking, watch this carefully. We are looking for a black man in a white shirt Watch. We're looking for the white shirt with shaggy hair. Because you're not sure exactly where the killer went. Look at this path. If you go up Fulton Street, instead of going left immediately, where they believe Andre Jackson went, and then where would be a good place to hide or cut through? Well, in between the Walgreens and the jewelry shop, right? You would go through there, and then maybe you could just come back down Henry Street and then get out Henry Street. Okay? So that would make sense because you don't know exactly which way the person left. All right? Now watch. You could also, once you get to that area, come through here, and if you see something you don't like, circle back, then leave and go down Henry Street. Watch this video. Watch it close. Look at the top Salvation Army. Did they do it? No. Could they have? Yes. Why didn't they go back in? Because the supervisor told them not to. Let that sink in, because you don't want to create evidence that would show he's not guilty. Your job is to question why. They were afraid of what they would not find. But don't they just want the truth? Two very important things they failed to do this prosecution. Okay? One, they did not prove that the Miami lab was approved by the Texas Forensic Science Commission. The law says, not by any other lab, the law says, and you remember the testimony, the law says that person must be licensed, if they're going to testify, licensed by the Texas Forensic Science Commission. You didn't hear that. And you can disregard her testimony if they did not prove that she was licensed. Also, this is the best part. Actually, Andre Jackson, or come stand behind him. He knew the name of the middle school. Oh, well, that must have solved the case, except for the fact that it was all over. He knew where the library was. Okay, look at him playing with his hands, right? All right. They'll also zoom in on a picture of Josue, but remember, emotions are not evidence. They will persuade you with emotion. That is theatrics and theater. And it's good, but it's not evidence. Richard Garza said, I had to keep going with the story. Ruland himself said, when someone puts their hands over their heart, that is a sign of compassion. And there he is. Why did Omar Garza pick Shay Calhoun of the photo lineup? He felt pressured and forced because he wanted someone to get caught. Lucky for Shay Calhoun, he had an alibi. But you know what? All of you are Andre Jackson's alibi. The 12 of you are. It's easy to say, screw that guy. Because that's what the cold case squad did. But what when you find out years later that he's not the guy? They are steamrolling Andre Jackson. That's what they're doing. Pay no attention to everything they didn't do, just what they want you to believe. Because Omar Garza said it best. He just wanted justice. Don't let this prosecutor, because he's very good, and that's what terrifies me, is that he'll guilt you into a guilty. Don't let him. Because he's not guilty. You know it.
Scott, you have about 20 minutes left.
How much time, Judge?
About 20 minutes, sir.
Thank you. So, I use notes. I don't have a PowerPoint. And normally, in closing arguments, I don't use any notes. But there's a lot of information here, that has not been covered, and so I may wind up reading from them, so I apologize for that. So I love it when the state of Texas anticipates what the defense case is going to be. And the state attempted to do that a few moments ago before Mr. Carter began his arguments. But I want to talk about something that we started a week ago, and that is, in my opening statement, I asked you all what is different now in 2022 than what the state of Texas had in evidence back in 2016, 2017. And we're right back to that question, okay? I want to begin with a date, which is May 17th of 2016, and that is the date where all this started, where Josue Flores was killed. And then we're going to jump ahead to June 18th, 2019, when Mr. Jackson was rearrested. But what happened in between there? So I want to go ahead and talk a little bit about the civilian witnesses. They are important. I didn't call them. We did subpoena them, but they became the state's witnesses. The state called them first, and they became their witnesses. Okay? Why are they important? There are lots of problems with them, but initially, at the very beginning in 2016, what did they do? What did they all do? They provided important information. Okay, what am I talking about here? Robert Figueroa. Now, Robert Figueroa is arguably the only person that actually saw the assault. And we'll get into that in just a second. But he was the first person on the scene, and he's testifying that he saw the assault. How did he describe the assailant? Black male, 28 to 32 years of age. This is his testimony. 200 pounds. Now, why is that important? You all have had an opportunity to observe Andre Jackson today, last week, and also the photographs that law enforcement provided to you all back in 2016 when he was arrested. 200 pounds, muscular, 5'9". He was wearing, Mr. Figueroa says, long black t-shirt, tan cargo pants. And, don't forget, black plastic bag. All right, interesting. What else does it not mention? Jacket. Green, black, green, no jacket. All right. In both his first and second statements, he was consistent with his testimony, his identifiers, and in neither statement did he provide any information about it. And he said, and this is important, and I'm not going to be this map up, I think it's a distraction. He does say that the assailant shot up Fulton Street. Okay? That's as far as he got, as far as where the assailant went. The interesting thing about his testimony, because it becomes really interesting later on with the state's witness, that he testified that the assailant Josue Flores in a headlock. All right? That becomes really important later on for both purposes. And why do I say that? Because I certainly didn't expect this during the course of the trial, but the very first lab that obtained the jacket and the clothing of Mr. Jackson and Mr. Josue Flores was the Harris County Forensic Center, Science Center, and the Houston Forensic Science Center. And why is this important? And understand this. If they treat evidence like that shirt to a degree where you cannot extract DNA from it, within a year of the incident, within a year of receiving it, how do you think they treat their other evidence that they received? This shirt that belonged to Josue Flores was so moldy that they could not extract anything from it. They didn't even bother to send it to Florida because she testified, oh, we do this all the time. And it was so very interesting. I asked her, does your lab allow that to happen? And she goes, she wouldn't answer the question. I mean, it was a simple yes or no, but she wouldn't answer the question. What she said was, our turnaround time is so fast that it doesn't happen. I mean, what good lab would allow that to happen? That you cannot use evidence. Important evidence. Josue Flores' shirt. Okay, so we have that. Okay, that's documented, and we brought that to your attention. But we also don't know, because the state of Texas did not bring anyone in from the Harris County, the Houston Forensic Science Center. We haven't heard from them at all. From there, it goes to the Texas Department of Public Safety. And what do we learn from them? That when the room that they use is prepared for DNA extraction, multiplication, swabbing, it is prepared by someone. And if that is not properly prepared, you can self-report that. I mean, we didn't hear anything about an incentive or anything like that, but that's all self-reporting. So if DNA is tested in that room, and the room isn't properly prepared, and maybe you have Josue Flores, maybe you have an unidentified person, and then you have Mr. Jackson's materials at one after another, which I suspect is what happens. Well, thank you, Judge. And then, of course, it goes to Florida. Now, I hope you all recognize that I wasn't trying to argue with the Florida analyst as far as her results. She got what she got from the labs that processed it before her. Okay? I was simply, at one point, trying to give you all an idea of how small or big this DNA that we've been talking about for the last week is. And what was her response? Oh, I can't give that to you. We have a mathematician that provides that information. The one thing that Dr. Benjamin did, and he may have gone over our heads just a little bit, is at least provided a formula. He attempted to give you all an idea of how small this DNA is and how small the percentage of both the unidentified person and Josue Flores is in relation to the total amount. Okay? You've got 85%, 10%, and 5%. And I just can't emphasize enough, we know it's Andre Jackson's jacket, and the way it was swabbed, it's very important because, and I understand, I'm not going to argue with why they swabbed it the way they did, but what she did is she accumulated all the DNA. And we don't know where it was located. We don't know if the unidentified third person and Josue was here, Andre was here, Andre's inside the jacket, the other's outside the jacket. We don't know that. We'll never know that.
Let's conclude.
Okay. And so, Dr. Benjamin doesn't work in a lab. He's not an employee of a lab. He doesn't have to protect his lab. The nice thing about Dr. Benjamin is not only his years of experience and his knowledge and his training, but he can take a look, an objective look at the labs, at the Florida lab, and say, this is what I see. And he wasn't even critical of the lab. You will notice he did not criticize her until she started attacking his theories. But what he said was, these are my findings. This is how big, this is how small, this is what they did. So, in conclusion, members of the jury, again, we have an individual here with no history of violence who was attending school that didn't meet the physical description of the civilian witnesses who are saying that they saw the assault, who's claimed that they chased down an assailant, chased it down a different street than where Mr. Jackson is depicted on. And we have an amount of DNA that is so small, so infinitesimally small, that could only have gotten there through transfer DNA. Somebody came into contact with Josue Flores, and then that person either came into contact with another person who came into contact with Mr. Jackson, or came into contact with Mr. Jackson. You've got a Salvation Army that had over 450 people, I believe, that lived there. And we don't know when that contact was made, because we do know that the contact could have been made, because it's possible, with Josue Flores before he was killed, if that unidentified person had somehow run into him on the street, then came into contact with Mr. Jackson. And it's possible that the contact with the DNA could have been made on the jacket as late as June the 3rd, when Mr. Jackson was arrested for the first time, because it could have still been on the person who assaulted Andre Jackson. And it could have been right there at the Salvation Army. Thank you, Your Honor.
All right, Mr. Norton.
I'm going to start and finish today with Josue Juarez. Have you thought about this picture? The Science Club, the end of the year. If you notice the clock on the wall, Josue kneeling in front, he will be dead in 15 minutes. And he has no idea. That's the last video that captures Josue. Literally walking to his fate. Within a block and a half, he will encounter Andre Jackson. And within minutes, he will be stabbed to death 2 blocks from his home on the way home from school. That is why we're here. I want to talk to you a little bit about defense's argument. somebody also gave me advice many years ago that when the defense is worried about the evidence pointing to to their client, at the cops. And for the first half an hour, that's all you heard. They're big boys and women. I am not going to defend. Sorry. I'm going to use all of my time talking about the evidence. Because that's why we're here. Also, the opening statement, they embraced Robert Figueroa. Remember? He said he was important in this case. Until he gets on the witness and hosts the case. And then today, embracing Ricky Garza. You know you're in trouble when you're trying to embrace Figueroa to prove your case. Right? And let's make no mistake of it. Ricky Garza did try to explain. I said shaggy hair, and he said, right? But I'll get to the individual witnesses in a moment. International testimony was accredited all over the nation, including the state of Texas.
Objection to the statement of the evidence.
It is not. I'm going to talk to you all about it. I mentioned it, but I want to. Remember when y'all were out there during jury selection, we talked a lot about a lot of stuff. Of course, you had no idea, did you? There was one question that I asked every single person out there, all 65, and said, you know, the state of Texas doesn't have a motive. Remember that? It's not an element of the crime. And there were 30 people out there who were not allowed to be on this jury that they would require us to prove it. It's one of the reasons why I asked every single one of you, do you need to know the why? Or is it just sufficient to know who and what? And I looked each one of you in the eye. And I asked you, will you require me to prove the why? And all of you told me, no. That's why you're sitting where you are. Because let's face it, is there ever a why someone would kill an 11-year-old child? Is there ever a motive to stab a stranger and leave him on the side of the road, dead like a dog? Would the state ever be able to get into the mind of an assailant like that? And that is why the lawyers would do this. I also want to talk a little bit about
To the last comment made by the prosecutor that it was comments on the defendant's right.
You know, we've undergone in the criminal justice over the last few years an evolution, right? For a long time, the system changed quite a bit, and I'm proud of the changes we have made. And at some point, I realized as we were working on this case that this case actually talk to you a little bit about that. One of the horrible things you can do is a rush judgment, right? Have time. What do we have in this? They rushed to judgment, which is the wrong guy. Shay Calhoun, who cooperated with Verify and then 48 days out of jail. It's a tragedy. It's horrific. It's awful. Were made. We told you in the opening statement that we want to be the first. Mistakes were made. We used to believe in eyewitness
as a holy grail. I myself, in being in my career, oh, wait, if a witness says this description, I'm going to believe it. If they say they did it, I'm going to believe it. In this case, we saw someone did that for Shay Calhoun, and they were wrong. We've now been educated over the last few years that identification is not holy grail. You need other. That's not evidence.
And I'm going to get to our witnesses, the citizen witnesses, in a moment. But it is powerful. Before you, this week, you have seen the evolution of our process. DNA, people for years. Why can't it be used to make you feel good about your verdict today? For too long, years in this country, in the state, in Harris County, folks in the past had great representation. That didn't happen in the courtroom over the last week and a half. These attorneys are they're brilliant, they're zealous, and you should be proud as citizens of Harris County that the likes Andre Jackson gets the representation that he got over the last week and a half. It's a new day. As also, when a few years after the arrest, a couple years, the DNA on the jacket came back inconclusive. There may have been an argument. Go forward and there's plenty of evidence. There was. But inconclusive does not mean exclusion. You heard that from the witness stand. Inclusive means they also knew that technology was growing. DPS told us that. Online to change. DNA technology was growing. So we made the difficult decision. I'm sure it was extremely difficult to accept. But the decision was to have restraint. And to give us a case, wait for the technology. There may have been a day where a prosecutor would cavalier and go in a courtroom, DNA pending. This case was because we're evidence. I want to talk to you about the witnesses. This is the map. We showed you a lot of surveillance, right? A lot of a map. But today, this boils down to 374. You see where that X is? That's where Josue. What is important about the witness? Remember, we talked about during jury selection. Remember? Oscars? Remember, as Shell, okay, we all knew who Rock and Will Smith were. Remember what they were wearing? You knew the tie Will Smith had on, Rock had on, right? Only 1 or 2 out of 5 remembered that Rock had a velvet jacket on. Why is that? Because you're watching a traumatic event. It wasn't as traumatic as this. You aren't focusing on what matters to you, right? But then remember I said, all right, what was NATO wearing? Now, a lot more people out there had a green dress. Remember that? Ladies in jury, you remember? Because it stuck out. So you see, when these witnesses all say
American male, late teens, green jacket. Now, Robert Figueroa did say, picked up like a trash bag. Do you think you could confuse this? Throw it over your shoulder. What's also significant, now they all are a piece of the puzzle as the assailant is running the scene. To get to Robert Figueroa in a moment, but when you are towering over someone who is 4'10" and 77 pounds, you look, you are 6 foot and 200 pounds. His perception. Then we have Gloria coming out. Says he had a green jacket on his shoulder. We have Ricky coming out saying he picked up the green jacket, put it over his shoulder. Why is that significant? Because when he gets to the end of the block, and what did Mr. John tell you? He booked a left. I'll tell you, he booked a left. They went, remember? Every single one said, went down the street and took a left. And Omar's standing there, in the corner, right? And what did he tell us? He tells us he had the jacket on. He's kind of messing with it, trying to put it on. You can't put a jacket on, right? And remember, I had Blanca get off and Sarah show me, and she took my hand away. And on the left, all of them have the jacket on the shoulder. To Robert Figueroa. Pay attention to the this 911 call. They come back to it if you don't, if he isn't able to play today. Right now, you can have it back. Because you will hear that 911 and ask for in the jury room at 6:43:01. That call drops. You know what Robert Figueroa was doing. Remember? He said he had observed the assault from a little bit of far. He thought it was a woman who was being attacked because of screams. Then the assailant runs down the block and then comes up to Josue and thinks he had just been punched. Then he sees blood. Right? And then